Hello there, welcome to Law Weekly on Channels Television. I am Shola Sheyemi. In the next 25 minutes or thereabouts, we'll look at a few issues concerning the discipline of lawyers and judges. Robert Clarke, a senior advocate of Nigeria, is our guest. But let's commence this proceedings the usual way with a recap of the top stories from the courts. We begin at the Supreme Court, which last week Thursday gave the federal government the last chance to settle out of court the lingering legal action on the legality or otherwise of the Sovereign Wealth Fund account operation. The legal action on the Sovereign Wealth Fund account was instituted by the 36 state governors against the federal government. The lead counsel for the governors, Senior Advocate of Nigeria, Adegboyega Awomolo, insists that the federal government is foot-dragging and reneging in the implementation of the out-of-court settlement proposals by the two parties. The Apex Court told the federal government legal team, led by Senior Advocate of Nigeria, Wale Alanipekun, that the dispute on the revenue allocation was political and would be better resolved out of court with a political solution. The court, presided over by Justice Walter Onoge, who led 6 other justices, said that the court would have no choice than to proceed to hear the case should the federal government fail to employ the out-of-court settlement for the last time. From the Supreme Court, we move to the Court of Appeals sitting in Benin City, which last week ordered the Inspector General of Police, Mohammed Abubakar, and the Attorney General of the Federation, Mohammed Adoke Bello, to pay the sum of 5 million naira fined them by the Edo State High Court into an interest-yielding account. The court, headed by Justice Helen Ogunwumiju, ordered that the payment be made pending the judgment on the arrest and detention of the Executive Director of African Network for Environment and Economic Justice, one David Ugulo, over the killing of Comrade Olaitan Oyeride, the Principal Private Secretary to the Edo State Governor, Adams Oshiomhole. After Mr. Oyeride's murder last year, David Ugolo was arrested by the police on the orders of the IGP after one of the accused persons reportedly confessed to being sponsored by him to carry out the act. Mr. Ugolo was detained for several months, but when the matter was taken to court for trial, he was ordered discharged and acquitted of the accusation, while the IGP and the police were fined 5 million naira for the violation of his fundamental human rights through his illegal arrest and detention. From the Court of Appeals to the Federal High Court, this time in Lagos, last week Thursday, Justice Okechukwu Okeke reserved judgment till May 16 in a suit against Barewa Pharmaceutical Company Limited, charged with the manufacture and production of an alleged killer syrup, My Pikin. My Pikin Thiedin mixture is a drug for children under the ages of 3. The drug allegedly killed over 18 Nigerian children. The manufacturers, Barewa Pharmaceuticals, and 2 of its employees were charged by the National Agency for Food, Drug Administration and Control, NAFDAC, on a 6-count charge bordering on the offense. The offense is said to contravene the provisions of Section 1, subsection A of the Counterfeit and Fake Drugs and Unwholesome Processed Foods Miscellaneous Provisions Act No. 25 of 1999. From the Federal High Court, we move to an Abuja High Court, which last week told the former chairman of the House of Representatives ad hoc Committee on Fuel Subsidy Regime, Honorable Farouk Lawan, and the Secretary of the Committee, Boniface Emenalo, that they have a case to answer. Farouk and Emenalo were accused by the ICPC of receiving the sum of $620,000 from a Lagos-based oil magnate and businessman, Femi Otedola, to influence the report of the committee in favor of Zenon Oil and Gas Limited. Ruling on the application to squash the charges, the trial judge, Justice Mudashiru Oniyogi, held that the charges do not constitute an abuse of court process as claimed by the accused persons. The court has therefore assumed jurisdiction to conduct the trial and has also held that the prosecution has established a prima facie case against both men from the proof of evidence placed before the court. We round off at the Lagos High Court in Ikeja, whereby Courtney Limited last week Tuesday lost an application seeking to quash the 4.7 billion naira money laundering charges instituted against the firm by the Economic and Financial Crimes Commission, EFCC. By Courtney, its chairman, Dr. Wale Babalaki, and 3 others are charged before Justice Adeniyi Onigbanjo. On the 5th of June, the court will hear 2 separate but similar applications filed by Dr. Babalaki and one of his co-defendants, Mr. Alex Oku, seeking to have the charges against them dismissed.
You see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
ChannelsTV.com. The news at your fingertips.
Welcome back. Last week Friday, the Legal Practitioners Disciplinary Committee, LPDC, derobed 4 lawyers on account of professional misconduct. Now, I've had people say to me that this action of the LPDC, though welcome, is coming late and is rather too little, especially when one considers the rot that has come to be associated with the legal profession lately. It was late Justice Kayode Esho who said a few years back that Nigeria now has millionaire lawyers and judges, many of whom are specialists in election petition cases. My guest, Chief Robert Clarke, has practiced law for over 30 years. He became a senior advocate of Nigeria in 2006. He's had the privilege of interacting and practicing alongside some of the best legal minds in the country. And he joins me now to give some perspective on the disciplinary measures and the standard of legal practice. On Friday, the Legal Practitioners Disciplinary Committee derobed 4 lawyers from legal practice. And what do you make of this? And I also want you to make a distinction for our viewers, especially those who seem to be getting the terms mixed up. When you say you derobe or you debar a lawyer, what are the implications? What does it mean?
Yeah, actually, every professional body has a disciplinary body within that body to look into complaints made against members of that professional body. The legal profession has its own disciplinary body, and this body, has the opportunity of listening to complaints from people who have cases against practicing lawyers or solicitors who are not practicing advocacy in courts. Now, the Bar Association's disciplinary committee looks into these things. And at the end of the day, depending on the circumstances of each case, they now come to a conclusion. When a lawyer is being debarred or derobed, that means his name is, either suspended from the names of practicing lawyers in Nigeria who have a license to practice in the courts, or he is expelled permanently from the profession. When you derobe or debar a lawyer, you are either suspending him from practicing his profession for one reason, for a period of time, maybe 5 years, or you permanently bar him from practicing the practice of law. So the important thing is that the barment or the robe means that a lawyer ceases to practice or to hold on the license to practice law in the courts in Nigeria.
Now, some people have described the action of the LPDC as being very insignificant, especially given the rot that is in the legal profession. A lot of people feel that a lot of senior lawyers are the ones, primarily responsible for some of the rot, most of the rot that you see in the profession. And this disciplinary action, well, we hardly see any disciplinary action being taken out against senior advocates of Nigeria. So a lot of people feel that this is not far-reaching enough and it's rather insignificant. Well, what do you make of that?
Well, let me be honest. Nigeria's image should not be looked alone from the practice of law. Right from the governance of the country to the executive operations of governance, to the legislative operations of governance, and to day-to-day governance by societies and individuals. Corruption has always been the main tone. And therefore, lawyers who are looked upon as the protector of the underprivileged or the protector of the law, find themselves, open to criticism where they fail in many respects. But there is no, gainsaying that the profession has its rotten eggs. But to say that the top of the profession is rotten, I will not agree. But I agree maybe there are rotten eggs at the top of the profession. But those who are involved, especially during the last saga about the Oshun matter, I can assure you that the senior advocate involved in that matter is under investigation by the Bar Association, and he's, before the disciplinary committee to answer charges in respect of that report. So
there's no conspiracy.
There's no conspiracy at all.
Especially among the senior.
No. I am aware within the past 10 years of one or two senior advocates who have been, disciplined by the, disciplinary committee and who have been suspended. Some of them appealed to the Supreme Court, and, it's an ongoing exercise.
Now, opinions are divided over the recent disciplinary measure meted out to some judges. Some people welcome it and say that it is a good development. Others see the NJC constituting itself into some kind of court of appeal. Do you agree with those who say that this procedure adopted by the NJC could intimidate the judges? I've been in a court where the judge asked, who are the reporters that are here, stand up and recount to me what happened. And then he tried to set the record straight and say, this happened because the prosecution and the defense agreed, and he was trying to justify what happened. And so some people say that this procedure of the NJC has the ability to intimidate and influence the judges negatively.
Let me say this clearly. It is the fashion now, and this fashion started when civilian government came in 1999, for people to start writing petitions against judges, either through civil matters or through political matters, but mostly through political matters. Now, I have been opportuned to act for one judge of recent, where I had to write to the CJN, because any Tom, Dick, and Harry who has something against a sitting judge and who wants to destroy that judge can just write a petition. And that is what is happening now. There is a particular judge who has been under a series of barrage of petitions, and we know from which angle this petition is coming from. I had to write to the CGN on one of them that, please, for God's sake, set up first a committee within the organization, so that when any petition is written against a judge, first send it to that committee to look into it first before you write to that particular judge. Because once you write to him, it goes into his records, and see whether that committee will find something substantial before you now write to the judge. My letter has not been replied to, and I think I wrote this about 3 months ago. Because if there is no checks and balances, and you just receive a petition, and you just send the petition to a judge, oh, we have just received the petition, please answer it within 30 days. You are allowing a situation in Nigeria now to happen where even within a family, if they have a grudge against a judge, they will just write a petition, and it is not fair. You see, maybe you don't know what, how do I say, psychological effect these petitions have on judges. When you see a judge who is being petitioned against and is being written to reply within that, and he looks at the petition and knows the source of the petition, he knows the circumstances of the petition, psychologically he won't be able to do anything. So I am not saying that petitions should not be received and sent to judges, but please, before sending the petitions to the judges, pass it through a channel where the committee will look at it. If, for instance, you say, oh, a judge, delivered a judgment, and you believed that he must have been influenced, you just don't send such a petition to a judge to say, you will now send it to this committee when you say a judge has been compromised. then you now ask the person who wrote it, come to this committee. What evidence do you have? Instead of asking the judge to reply to such a, even if a judge has been compromised, do you think he will agree that he has been compromised?
Now, what would you say to people who say that we don't have the kind of caliber of judges and lawyers that we used to have in the past? When you talk of the likes of Justice Kayode Esho, the late Justice Kayode Esho, lawyers like Rotimi Williams, and we don't have the kind of caliber of those judges and lawyers in the profession anymore. What would you say to people who say that?
Okay, let me look at it from this angle. As a practicing lawyer, I believe something has to be done about appointment of judges. I believe the system of appointing judges in Nigeria needs to be reviewed. For instance, when you find majority of judges in a particular state never practiced, either they were in the civil service, either in the banks, either who have never practiced law, and they find themselves sitting as judges. Their capacity to know what the lawyers are thinking, and many things are deficient in their sitting as judges. Those are people I think should not find themselves in the bench. And to be honest, many of them there today do not have the, In England today, you find Queen's Counsel. Many of the judges will have attained the grade of a Queen's Counsel before being appointed as judges. But here you find, a civil servant who has just done 10 years, maybe in the DPP's office, has never widened his practice. He finds himself, after 12 or 13 years practice, within the civil service enclave, being a judge. And then you find him taking civil cases. And then you find that his attitude even to sittings in courts is not regular to, in sitting down, because because time is of the essence to every lawyer. So I agree with you that because of that deficiency, we have not been able to have those caliber of judges that we had in those days. In our young days of practice in Lagos, we knew judges like late L.J. Dosumu, like Oluwa, who are seasoned lawyers before going to the bench. And you can see the difference. You can see the difference. So I will agree to an extent that the caliber of judges we have now do not represent the standard of, professionalism that Nigeria knew before. And if a little bit of, reform is being done now to allow majority of judges to be practicing lawyers rather than civil servants, then maybe we will see a difference.
The same could also be said of lawyers. We don't have this caliber of lawyers, the caliber that we used to have, back in the days.
Well, let me put it this way. Nigeria has developed to a standard, applicable to any standard in the world now. In the days of Rotimi Williams, there were few lawyers. Maybe, and the rising stars, you can easily see them. I agree. But you have within the bar today, you have people you can compare. Practicing lawyers, you can compare in their standards to those of Rotimi Williams and others. It is only that the attitude of Nigeria now is different from the attitude we had during the colonial days and the 60s or 70s. But I can assure you, standard now has even risen higher than the standard when Rotimi Williams were all practicing. Because the ability to know how to find the law, the ability to do research are now more easily accessible to lawyers than those, For instance, I remembered when I started practice, we had no law reports to really accept the Supreme Court reports, no digest, no nothing. We have to be carrying our notebooks to court, listening to senior lawyers, citing cases, and But it's different today. Today, the practice has attained a height where the best brains can stand even better than the Rotimi Williams.
When you say that it's not a case of falling standard of the legal profession or the legal education, could it be a case of lack of proper mentorship or guidance?
Well, let me tell you this. Young lawyers my advice to young lawyers is that when you leave the law school, find yourself attached to a chambers that is well established. Forget the money aspect. You see, money is a gift of God, as I tell my junior lawyers. Money will run after you if you are hardworking and you are diligent in your practice. The money will come after. But as a young lawyer, if you attach yourself to a chambers that has a reputation for hard work, that has a reputation in handling cases, and has seasoned, you see, advocacy is a forensic art. You either have it in your blood or you don't have it. Some people work hard as lawyers, but that art of advocacy is a gift of God. It's just like a doctor who has good fingers to cut. No matter what you read in the books, it's an art. So there are certain lawyers in Nigeria today who have that forensic art of advocacy imbibed in their blood. Many of them are not known because they don't do political cases. So you find that many lawyers who are doing political cases may not be good in other areas of the law. They make more money in that area, so it is all political cases. And many people are using them as an example to relate to lawyers. There are many of us lawyers today whose practice is so wide, and advocacy, should not be determined from the political cases. For instance, for the past 5 years, I've refused to take political cases because I am more inclined to do my arbitration work or to do other top cases, that my forensic art and my knowledge of law will be more exposed. So the standard is high, the practice is high, but it depends on the exposure. Because what is being exposed to the average Nigerian today are lawyers who are handling cases for either the president or for governor this or for governor that. So that people are taking their standards as a standard of the profession. The profession is rising high, I can assure you that.
That's our interview and the program this week. For feedback and comments, do get in touch via the addresses on the screen and follow me on Twitter @IamShola. Thank you for watching.